First of all, just welcome to everyone who's joining us here at the Republic of Work, Lunch and Learn, and thanks for taking time to join us. So we're going to provide a presentation on IP for startup businesses. Our firm, F.R. Kelly, we have our Cork office in the Republic of Work, and we look after the IP interests of a lot of startups and SMEs and larger companies as well in the Munster region. We've been working in IP for over 90 years. We have 70 people with offices in Cork, Dublin and Belfast, and we've expertise across all areas of technology and IP. So what we're going to do today, we have 3 short presentations, 10 or 15 minutes each. And then we're going to have some questions and answers. I'd like if everyone, if you're not muted, put your mic to mute. And if you don't get a question answered, you can obviously contact us afterwards. We'll have email addresses. You can contact me at d.brophy@f4kelly.com or any of the other speakers who are talking today. So the first speaker is going to be Maura O'Connell. She is a partner in our life sciences patent practice and has a lot of experience working with startups and spin-outs and SMEs. And she also looks after the European patent portfolios of some very large multinational companies. So if you have a question about patenting, Maura has almost certainly dealt with it before. Then Shane Smith is going to talk to you about trademarks. He's a partner in the trademark practice. He's a solicitor, and he's also a qualified European patent attorney. And Shane is a co-author of the leading textbook on IP law in Ireland. So if you have any law students who come out of any of the universities who know anything about IP, they probably learned it from Shane's book. And he's going to talk to you about trademarks and how you secure your brand. And then I'm going to take the third slot and talk about designs and copyright. And after that, as I say, we'll have questions and answers and hopefully finish up on time. So I'm going to turn it over to Maura, and she's going to talk to us about patents.
Thank you very much. I hope David didn't oversell me there, because I will try and answer any questions you have, but whether I can answer all of your questions about everything to do with patents might be a bit of an ask. So we've split the intellectual property presentation up into 3 different segments. I'll be looking after the patents part of it. But I suppose just to bear in mind that intellectual property is this big overall umbrella term, and sometimes different parts of intellectual property, more than one, may apply to what you're doing. Now, if I could only get my thing to work. Nice. Oh, there we go. So I suppose the first thing I really wanted to talk about is why bother with patents? Well, the first thing is that each of you is in a startup situation, and you've got an idea, and you want to run a business with it. And so the first thing that a patent will do for you is it's a defensive strategy, because you commit to paper what your invention is, and it allows you to prevent other people from using your clever idea. So it does warn off competitors, and it can be a useful defensive strategy. But it is also an offensive strategy, in that at the moment your business may not have a very long trading history. But having granted patents adds value to your overall IP, your overall assets within your company. And for that very reason, it also helps you to secure investments. So then moving on to what patents are, they are intended to protect how a piece of innovation works. So the innovation functionality.
Maura, just to let you know, we're not seeing any slides from you. I don't know whether you'd started to share. That's okay.
I thought I had, but excuse my language. Share.
Yeah.
Now I am screen sharing.
There we are. Yeah, great.
Okay, we're back to the beginning there, and that's the introduction. Not going to worry about that. This is the second slide then, where I was talking about the defensive and the offensive reasons for considering patents. Defensive to protect whatever it is that's clever about your startup, and offensive to add value to the overall assets of the company. And the next slide, then we're talking about what is a patent, and it's intended to protect how your piece of innovation functions. Then, if you look at the bottom left of this slide, you'll see a Venn diagram where you have an overlap between prior art and the invention, and the area in the middle, the deeper pink, is where there's an overlap between one and the other. And what we're trying to get across here is the idea that it's very unusual that you would be the first in your field to make an invention in an entirely new area. And so mostly inventions are made, they're incremental improvements on what has gone before. And we make this point then in relation to the telephone here, where we've a very old, probably one of the earlier models of a telephone in quotes, and then a more recent mobile phone, and not even by the look of it, their most recent model with a protruding antenna on it. But in each of those inventions, each of those iterations of the telephone, there would have been an improvement that was made, and whoever was clever enough to think up that improvement would have tried to protect that piece of improvement by way of a patent application. So what can be patented? The general thing that I wanted to talk about then is what is an invention? And it's kind of a gray area. It's something more than an idea or a discovery, and it's something that has a technical content. So that feeds into the second box of what we're talking about here, which is that the invention should be technical. And then, of course, there are rules for what's patentable or not. So then moving on to the next slide, what are the criteria? And they are the three main ones. Just waiting for the third one to pop up here. Yeah, the three main ones are that the invention must be new. An invention is new if it is different in some way, even a small way, from anything that is known before, and that's anything that's known anywhere in the world in any language that's in a public setting. So novelty, it sounds like it's a difficult thing to overcome, but it's not too bad. It's black and white. You either have something that is new or you have something that is not new. If you have something that's new, we then move on to the second hurdle, which is inventive step. And this is a more difficult one to get across to you what's involved, but it's also a more difficult one to satisfy because it's something that's subjective. So what is it? Basically, it's the idea that you've made a change, and it's either it's got some kind of surprising or unexpected effect with it. So that's inventive, but we will talk about that a bit more because there's a lot to talk about in relation to that one. Industrial applicability, the third criterion, then it's a fairly low hurdle to pass. It just has to be something that kind of works in a real world setting. You don't actually have to have the actual prototype, but it has to be something more than a perpetual motion machine, for example. So the difficult criterion there too that we're always looking at is the inventive step one. The other two are easier to get past. And coming back to the novelty one, this one kills me, and so I wanted to put this one up. Any disclosure that's made by you or by anybody else in a public setting, whether it's on the internet or it's even a public sale, if it's in a public setting, it's fatal if somebody can prove it for your patent application, because your invention has to be new against everything that's gone before. So if you pick up nothing else from this presentation, is to be very careful about what information you share and with whom you share it before you decide whether to file or not. And I know this is a particularly graphic trap here, animal trap, but it's to make the point. It's a killer, this one. And so if you can bear that in mind, that your invention has to be new before you file, that would be great. I have seen over the years, particularly in an academic setting, I've seen poster presentations, I've seen recordings of conferences, I've seen theses all being used to devastating effect against somebody's patent application. So I think I've over-egged that point enough. So coming back to the middle criterion there that we were talking about, inventive step. really the questions that we'd be asking and we'd be asking of you as the inventors is, does the invention, does it solve a technical problem, and does it provide a technical solution? And I know you're going to ask, what does technical even mean in that context? So here are two examples to show you what I do mean. So this first one here is software that improves audio data. It can be the facial recognition software in your phone or your camera. It can be red eye removal. They are all technical problems, and addressing those all had technical solutions. So in terms of our technical problem, technical solution, this is the kind of thing that would be patentable. So then to take the flip side of that, here's another example. How do you keep track of your HR data? So you might buy a software package that captures the arrival of your employees, their training history, and the like. Now, this is neither a technical problem nor a technical solution, because what you've done here is gather together information which might have been kept in voluminous physical files before, but you've gathered them together into an overall software package. And this, at the other end of the spectrum, then, is not patentable. Another thing I just wanted to say in relation to inventive step is, as the inventor, you're probably the worst person to decide on whether something is inventive or not, because you're too close to it. And so the patent office has set the standard of, is it obvious to somebody skilled in the art? But that person who's skilled in the art is not the Nobel Prize winner. It's not you, because you're in it. And once you get that far into it, it's very hard for you to be objective and say, well, actually, there's something surprising here. So the standard is judged against somebody, relatively ordinary, who has some knowledge in the area, but not the same amount of knowledge as you. And that should be hopefully a comfort to you. As David said then at the beginning, then we have been helping Irish inventors and international inventors since the firm was founded in 1927. Not all of us specifically, but the firm in general. And these are just kind of a snapshot of names of different firms that we have helped to protect their inventions for in the past. And you can see that they're everything from dairy and functional foods, mechanical, software, medtech, clean tech, you name it, and we probably have seen it at some point in time. Just in terms of very general detail, then, just to explain that there are different kinds of patent applications. Most people file in one country. First of all, it can be in Ireland or in the United Kingdom. And then they have a 12-month period to protect their invention abroad. And most people at that stage, at the end of the 12 months, would take the option 6 there, which is the international or PCT version. And that gives you another 18 months then to figure out the countries that you might want to get protection in. And so that's like a really quick overview of the kinds of patent applications that are available. And that's something that, we would talk to you about when we're talking about what your invention is, what kind of countries you would want to cover it in, and over what period of time you might want to do it. And so I suppose I do want to leave you after all of that information with a more encouraging note, and that is, do consider taking your first patent step and do consider getting patent pending status for your invention. As well as the negative thing that you might be sorry that you hadn't in the future, it's a good thing to consider doing. All the more so now since Enterprise Ireland are offering IP audits to any of their clients, where they will pick up to 80% of the costs of having a consultant come in and do an audit of your company to see what it is that might be protectable. So for 3 days of consultancy, you would end up just paying 20% of the costs. So thank you very much. And now I will attempt to pass it back to David. I will stop share.
Sorry, thanks very much, Maura. That's great, thank you. And should actually add, in addition to the ongoing thing that Enterprise Ireland have, the EU has launched some packages specifically directed at SMEs. You wouldn't even have to be an Enterprise Ireland client, and they have assistance that you can get both to get an IP audit and also if you're filing trademarks and designs, where they will pay 50% of the costs. So there's a lot of help out there, and we would be quite happy to point you in the right direction for those. So I think next up we're going to have Shane, and Shane is going to talk to you about trademarks.
Okay, good afternoon to everybody. Trademarks is again one of the Maura's mentioned that the umbrella term is intellectual property. The area I'm going to talk about as a subclass of intellectual property is trademarks. And Brian, you could put up the first. This is. Did we hear that? Okay. This is what is called a motion mark. And motion marks are, in fact, a new category of trademark that you can register now before in Ireland and before the European Union office. And in fact, we have applied and have been approved registration for our own motion mark. And in fact, it's the first motion mark that's been filed in Ireland. Now, what is a trademark? A trademark is essentially any means by which you can distinguish your particular products and services, activities from those of other people. And I've listed some of them there. And of course, a trademark can be a combination of some of these as well. Not all trademarks can be registered. There are certain difficulties, for example, in registering trademarks which consist of smells. But most trademarks can be registered, provided that they are sufficiently distinctive and that they don't directly describe the range of products and the services which you are going to provide under the trademark. So the first thing that you need to do is to look at what you're doing and say to yourself, how are you distinguishing your activities from those of others? Almost certainly you've got some word trademark or a combination of words. In a lot of cases you will have logos, but you may have other forms of trademarks, again, which you can talk to us about registering. And why would you register? You register to get the strongest form of protection to prevent other people from using any other branding which is likely to cause confusion with your own. But trademark registration is not mandatory. It is very advisable, but it is not mandatory. You can move on, Brian, to the if you're in a greenfield scenario and you're creating your coming up with a trademark from scratch, it is advisable to do some searching of your own. And then you would come to somebody like us to look at doing more extensive searching. So, for example, in quite a number of occasions, people's business activities would be absolutely be imperative that they have for the .com as a domain for advertising and promoting the services which you have to offer. And therefore, if the .com is gone, then you do have to, if it is imperative for your activities, then you would start to look elsewhere. But do initial searching of your own. Again, contact us and we would give you some ideas of the 3-to-use databases which you can search and how to search them. And then once your initial searches are clear, you'd come to us to do more extensive searching. And the searching is not just to make sure that you, as far as possible, you can register what you're going to come up with, but also you don't want to start using your trademark and suddenly you find you get a letter from somebody telling you that it's too similar to their own mark and that you've got to stop using. Okay, so that's the importance of getting brand clearance. Okay, Brian? Then you apply to register, and you register generally on a country-by-country basis. Okay, but there are some very strong exceptions. The biggest exception would be that there is an EU trademark registration system. There is also an EU design registration system, which David is going to talk to you later about. But what you can do is you can file an initial trademark application in Ireland. And under an international convention, you have 6 months then within which to file a corresponding trademark application in other jurisdictions. And if you apply within 6 months, you can claim the date of the Irish filing. Okay. Obviously, with the departure of the UK from the European Union, the UK is, well, it's now inundated with national trademark applications that people are filing nationally in the UK because it's no longer part of the EU trademark registration system. Each office will carry out an examination of the application. Many offices will carry out an examination against existing trademarks, and they also examine and will refuse trademarks if they view the trademark as being too descriptive or not what we call non-distinctive. You don't have to have invented words. Ordinary dictionary words can be registered as a trademark provided they don't describe the product concerned. So, for example, you could register, well, subject to carrying searches, you could register, for example, the word banana for clothing, but you wouldn't be able to register it, obviously, for fresh fruit and vegetables. In fact, you probably wouldn't be able to register banana for clothing now that I think of it, because obviously Banana Republic would be a well-known brand in the clothing area. But again, this is searching, clearing, and then filing the first trademark application in order to preserve your position. And this is where we can advise you. Brian, you can move on. When you get a trademark registration, you can use the R symbol, not mandatory, but again, it's a good idea. It denotes registration. And there is a use it and lose it philosophy in most jurisdictions. So, you know, if you do have a trademark registration, then you will have to use it, or your trademark can be challenged and removed from the register. Unfortunately, in most jurisdictions, they are now moving in a direction where you have to monitor and you have to keep a watch of your own against conflicting trademarks that people are filing, because many of the offices don't actually carry out searches themselves against earlier marks. So again, that's something that it's a service that we offer. Okay. Many trademarks are licensed. You can license third parties. You get royalty payments on foot of your license, and there are also certain tax advantages which you can avail of in internal licensing between, for example, you could create a trademark or a patent, an IP holding company, and register it to the and license it to the actual user company within your group. And Brian, over to again, regularly audit your business for intellectual property. This is why we're around. Look at what you have. Look at what you trademarked. Come and talk to us about, look, we think this is a trademark. Can you register it? Every time you get a new export market, come and talk to us about, you know, the protection that you need abroad for that particular trademark registration. Again, when you expand your product range, you're moving to different fields of activities. Again, you come and talk to us about taking out trademark registrations. That's it. I know David's going to talk to you now about designs and copyright, and there is an overlap in many cases between designs and trademarks, and I'm sure David will touch on that. And again, I'm open to answering any questions which you may have at the end. Okay. Thanks, David.
Great. Thank you, Shane. So yeah, I hadn't actually planned to talk much about the overlap between designs and trademarks in this particular talk, but we'll do our best. So I'm going to talk about the third main area of IP, I suppose, which is designs and copyright. And when I'm doing that, if I can get control of my slideshow, sorry, let me just. Are you seeing that they're changing? Great. Okay, thanks. So design rights are probably less well known than patents and trademarks, or at least they're not at the forefront of people's minds. They've been called the Cinderella of IP for that reason. I don't want to describe patents and trademarks as the ugly stepsisters, but certainly they get all the attention and they're the ones who've tended to go to the ball. Designs are in the background, or have been traditionally. They've been sort of ignored and unloved, but that's changing as companies start to realize, A, how easy it is to get designs registered, and B, that they're expanding, the rights under designs are expanding into areas like overlapping with trademarks, and they're used as a backup sometimes to trademarks. So where patents refer to how something works, how it's made, how it technically operates, and trademarks refer to your brand, designs are about how something looks. It's all about visual appearance. And it's not just the visual appearance of physical products. As you can see with the fourth image, it can also be a digital design. It's how something looks on screen, which expands things out considerably from traditional designs. In Europe, we have two kinds of design protection. There's registered and unregistered protection. Generally, you want to try to get registered protection if you can, because it is stronger and it lasts longer. It lasts for 25 years, whereas if you rely on unregistered rights for your designs, they run out after 3 years, and they're also more difficult to enforce, because you've got to prove that the other person copied you. If you have a registered design, you've got 25 years of protection, and it's absolute protection against anybody who uses the same design. So a much stronger form of protection. So here's an example of unregistered designs. This is a case, it's quite a number of years ago at this stage, and it was where Karen Millen, the clothing company, had come out with the shirt on the left, and Dunnes Stores came out with a shirt that coincidentally looked very, very similar on the right. And the evidence actually showed in the court case, Karen Millen sued, saying that Dunnes had copied, and they said, we have unregistered design rights in our shirt, and Dunnes have infringed that. And it turned out that Dunnes had actually gone in and bought the Karen Millen shirt in different sizes, and the evidence showed that they had then gone to their clothing manufacturer and said, make something as similar as you can. And in that case, Karen Millen succeeded in taking Dunnes off the market and getting some damages. But it was, as you can see, it was a very blatant copying, and the evidence was there to show it. You can't always prove things as easily as that, but this is where unregistered designs can be useful. For registered designs, as I said, you get 25 years of protection, and you don't have to prove that there was copying. So if you have protection for a bottle that looks like this, then anybody who comes out with the same appearance of bottle will infringe your design registration, and you can stop it. When you're registering something, you can register the whole of the product, or you can pick out parts of it, the parts that you think are visually important, and you can get registrations for individual parts of your product. So this is a very useful way of getting a number of registrations for different aspects of your product that can help you to kind of extend your protection. So what does a design registration look like? This is a traditional one. And basically, it's just pictures. It's pictures of your product shown from every side. And that's what you put into the patent office. They will look at it. And if the pictures look OK, they will give you a design registration. And now you have the right to stop other people from making this particular telephone. Some other examples, again, traditional products. You can see that there are broken lines being used here on the wheels of the car and extensively on this older version of the iPhone. And what they mean is it's a shorthand for saying that the protection is not limited to the shape of the screen or what the back of the phone looks like. It's any phone that has this curved bezel around the edge and which has a circular home button. That's what's protected, and it's only that is protected. And then, like I said, you can have digital designs. So we can move away from the physical world. And each of these is a design registration that Apple has got over the years for some aspect of their operating system. The idea, the strategy here is if they can protect every little part of their operating system, it becomes very, very difficult for someone like Samsung to make an Android operating system that looks the same and feels the same as the Apple one, because they've kind of shut off all of these areas and they've cut them out by getting protection around each little part of it. And you can see again another design registration, this one Microsoft have for the Word icon, and they have that registration. And they also have a registration where it's not in color, and where the W doesn't matter anymore, as you can see, because it's in broken lines. So this is a much more generalized and broader registration. And companies will do that. And we'll talk to you if you have digital designs or physical designs about what's the best way of protecting the essential parts of it so that people can't copy it. And like Shane had said, you can do this not just for an icon on a screen or for part of a graphical interface, but you can also do it for any graphical symbol, and that could be your logo. And what a lot of companies will do is they will look for a trademark registration primarily to protect their logo, but sometimes if it's an important part of their brand, they will also get a design registration, which has some advantages in terms of how quickly you can get it and how easy it is to enforce against somebody who copies it. So, you know, we would look at a combination of strategies, and you can have overlap. So if you take something like, you know, a Dyson vacuum cleaner, there will be patent protection around all the technology inside it. There will be a trademark for the Dyson brand, and there will be design protection for how it looks. So all of these kind of forms of protection work together to protect your IP and your product. And then the last one, I mean, Shane started off by showing the F.R. Kelly moving trademark. You can also get moving designs, which is quite a feat when you have pages traditionally on paper. But what you do is you show the moving design in a series of snapshots as it moves through this progression of images, and you get protection effectively for the animation. And this is becoming, you know, it's very widespread now that companies will have moving designs, you know, screens that dissolve and screens that change, and that's something that can also now be protected. So the design system, even though it's very old-fashioned or has a long history, it is adapting to the digital age as well. So why should you register your designs? The primary one, as with any form of IP, is you want to protect against people copying you. And that's something for every business. If this is a core part of your business, you don't want people to take it from you. So you get a registration of some sort, patent, trademark, design. you use that not just to sue people, but also to deter them. Competitors, you often won't know that they've looked at your IP and have decided to take an easier route. They've looked at your IP, seen you've got protection, and they've moved away from it. They've gone around it. So it can work silently to deter people. It also can help you to get some registered IP on your books. Sometimes, you know, investors will want to see that you've done what you need to do to protect your IP. And so, you know, having design registrations where a patent might not be available, or if it's going to take a long time to get a patent through, having some registered IP quickly can help you and can give your company some credibility. And then with designs in particular, it's probably, well, it certainly is quicker than patents and trademarks to get a registration, and it's usually more inexpensive as well. So it can be a way for companies to get a foot on the ladder quite easily. And also, designs overlap to a certain extent with copyright. And copyright is something that businesses, I think, need to know about, not just in terms of protecting what they have, but you need to be aware about copyright so that you don't get yourself into trouble when you're running your business. And a lot of companies do get themselves into trouble by not paying attention to copyright. So what is copyright? It's an unregistered form of protection that covers lots of things, mostly creative, literary and musical and artistic, but also some things like databases, which are more technical than creative. But all of these headings are protected under copyright law. A few of them are, most of them are maybe not important for every business, but a few are important, I think, no matter what business you're in. So literary works is not just books and novels and stuff like that. It's also all of the written materials that you create in the course of your business. You have copyright in that. If you have any software, if you either write software or you commission software, that software is regarded as being a literary work, and that's something that's protected. And then, of course, you'll have a website, and all of the text that you've written for that website is protected and is covered by copyright, provided that you've written it originally. If you start copying someone else's text and putting it onto your website, you're getting yourself into infringement. So you want to make sure that anything that you use in your business, you have created yourself, or you've paid someone to create it, or you have licensed it. You don't just take stuff that you find lying around on the internet, because it's not just lying around, somebody owns it. Artistic works, obviously you create drawings, you have photographs taken for your business, you create logos which have an artistic element to them, and again, your website. All of these things are protected. The photos is one that I think most businesses, most companies are guilty of taking photographs. They see a photograph, they think that would look good in our brochure on our website, and they use it without thinking too much about it. Don't do it, because you're opening yourself up to an unnecessary liability. And it is usually possible to find, licensed works. There's Creative Commons, there's plenty of photos available, plenty of images. You can either pay a small license fee or get for free and avoid any trouble. I mentioned databases. These are kind of an unusual thing to fit into copyright, but what they effectively are is any collection of organized information. And if you think about your business, you may well have gathered together information, and it's the gathering of the information that's valuable. And if you have spent time and money or effort and resources in putting together information in an organized way, and you want to stop people from copying it, then you can get protection for that under copyright law. This can be very useful. Sometimes we'll have companies where they don't create anything themselves, but they have they've gone to time and effort in gathering together a product catalog, and then they find that people are lifting that product catalog, or they're copying it, and what they're actually doing is infringing their database rights. So it's something to be aware of, that you do have this protection automatically if you've made the necessary effort to gather stuff together and arrange it. Avoiding copyright infringement, I think, is as important as knowing what you can protect yourselves. It's only infringed by actual copying. So you can't infringe copyright if you happen to come up with the same thing as someone else. It's only if you've actually copied someone that you will infringe copyright. So you create your own work, or you get someone to do it for you. And when you get them to do it for you, you make sure that they assign the rights to you. That's really important. There's I think, an understandable idea that if I pay a company to create my brand, or I pay a company to create my website, that I own it. You don't own it until they assign it to you in writing. So you've got to be really careful and diligent about doing that. So that's what this slide is about. If they're an employee, you generally own it. If they create it as part of their employment, then you will own it automatically under Irish law. We want to build that into your contracts of employment, and look at any contracts for any employees to make sure that you own their IP. If they're a contractor, you must get an assignment, and you can have that assignment be retroactive. So you can go back to a company and say, look, you created this for us a couple of years ago, we paid you for it, and now, you know, F or Kelly are telling us we have to get an assignment, so can you just sign this document? And usually that will work, and you can get it assigned to you. Where this can cause you a problem is if you try to get funding in, you try to go for another round of funding, there's due diligence from an investor who wants to come on board with you, and they start asking questions. Well, you know, your website, do you have all the rights in that? Do you own your logo? And when you try to answer those questions and you dig into it, you realize you never got these things signed. So try and build it into the contracting process that you will have these things assigned over to you. If you create something yourself, how do you secure it? Well, there's no registration. Unlike with trademark registrations, designs, patents, you get copyright automatically. And it exists as soon as you record the work, as soon as you set it down on paper or save it as a file on a computer. But because it's automatic, you want to keep good records. You want to be able to show at the end of the day that you had it, you know, in May 2021, you had created this, and you have a record of that that's reliable, and that a judge will take your word for it on the basis of the evidence. You want to mark any of your works with the year and with your name, so that puts the world on notice that this is not free to use. They have to come to you for permission to use it. And as I said, really important to get an assignment and a license for everything that you use in your business. So that's a lot of information in a very short period of time, but hopefully it gives you a flavor for how these things are important for your business. As I've said, you know, we'll take some questions and answers, but, you know, we're available by email. Either you'll find, you know, contact details on our website. That's my email address down there. And I'm sure Maura and Shane would equally be very happy to deal with any questions that you have. So we have a question. We've got one question asking if we can email the slides, and Angie, I think you'd be able to do that for people. You're just on mute at the moment.
I'm on mute. Yeah, so we'll be sending out a feedback email. So what you can do, Colm, is you can, or sorry, Cody, you can just reply to the email that we send out and just request the slides, and I'll be able to send them on to you, or you can DM me your email on Zoom here and I can send them on to you as well. And then with the recording, you can see Maria has asked about the recording. So we'll be putting that up on our YouTube channel in about a week. So there'll be a link to the YouTube channel in the feedback email as well. So you'll be able to see that there. Thank you, Rick. Rick says, great presentation.
Okay, well, thanks very much. If anybody wants to either put up a question in the chat, or there's a small enough group, if you want to just ask the question on screen, you know, you're very welcome to. Maura, I was just going to, maybe one thing that came up in your presentation was about, you know, putting things into the public domain destroys novelty. Obviously, we're often asked about, what about if you disclose it under a non-disclosure agreement, or can you talk to people about it if it's not public? What are the rules on that side of things?
You don't have to have a non-disclosure agreement in writing. It can be assumed, but it can be sometimes hard to prove it when it's not in writing. It can a confidentiality agreement can be relatively simple. You know, before I pass you a prototype that I've made in my workshop or whatever, I want you to understand that this is confidential, and I want you to sign before I hand it over to you. Or it can be a slightly more legal version of that. So that is a possibility. What happens then when you don't have a confidentiality agreement? And there was I think a UK case fairly recently about a farmer trying out some kind of an agricultural piece of machinery in his own field. just to make sure that the thing worked. And that was found to have been a public disclosure, because there were a couple of spots around the fence where the bushes weren't high and where there was a gate, and where somebody might have looked over the fence, or they might have got a drone and just might have had it circulating in the field while he was doing this. So yeah, you've got to be very, very careful about disclosing. And as I say, you can do it informally by saying that what I'm about to show you, I want you to keep private, or you can have a confidentiality agreement in writing, a more formal one. But either way, the problem with telling somebody and then if they go and break your confidence afterwards is you're going to end up probably in court, because you're going to be saying, I showed this to a another, and I had, here's the email saying that we were going to keep it on the QT, and then a another went and sold samples of whatever. But then you're in court because you've got to establish that there was a confidence arrangement between the two of you, and then to assess the damages. So best if you can to be careful about how much information you put into the public domain before you decide what to do. Not always possible, I know, but sometimes that might mean that you might check out one part of like a conventional machine with one person, and then on the QT, and then check out something else with another, so that one person doesn't have an overall sight of the overall piece of machinery or whatever.
Okay, right. Yeah, I think the farmer in the field is an interesting one, because it's a difficult invention for him to try out without putting it into a field somewhere, and like you say, you can't protect against drones, and we'll see that in medical devices or in some technologies where you just have to test it with members of the public, and so with those, I think you just have to file your patent before you start that process of putting it out there. Shane, one thing that I know comes up a lot, and you talked about searching in your talk. What happens if someone is doing just some general internet searching and they find that the brand that they've picked, or maybe the brand that they've already started using, is being used by someone else, but it's in a totally different area of business? How does that work?
Okay. Generally, trademarks are restricted to the field, or at least similar field to those in which the trademark is registered. So often identical trademarks exist, held by different owners because they're in different fields of activity. So for example, I know that the trademark punch, I know it's a shoe polish, I know it's a magazine, I know it's a herbicide, I know there's clothing. So all of those are held by different owners because of the different field of activities. That's the general rule. Exceptions to the rule are trademarks which have a reputation, which cross all boundaries. So it doesn't matter what you use Lego on, it's going to be a problem, even if it's in a totally unrelated area to toys. But that is the exception, very much the exception rather than the rule. And when you register a trademark, you do so in specific classes. There's an international classification, and we put the goods and services into that classification. And when you're searching against trademarks, know what classes you need to search in. Again, we'll advise that. So if you're coming out with a new gin product, your class that you need to search in is class 33, but also related classes like non-alcoholic beverages and even restaurant and related services. So to answer your question, the general rule is the activities do need to be at least similar before there's a problem, with the exception of trademarks with a reputation.
Okay, great. Thanks. Okay, well, look, I think we'll leave it there and let people get on with their day. I want to say thanks to Angie and the Republic of Work for allowing us to come and talk to all of you. And I want to thank Maura and Shane, obviously, for their interesting talks. And obviously, then finally, thank everyone who has turned up and listened to us today. If you have any questions, get in touch with us, f4kelly.com, and you'll be put in touch with the right person, and hopefully we can help you with your IP. So thanks very much, and goodbye, everybody.